Can a police chief suspend the Second Amendment rights of his city citizens? One Florida police chief just did exactly that. Sound crazy? Unconstitutional? Against the actual law? It's all of those things. So let's dive in. Welcome, everybody, to today's episode of the Law of Self-Defense Show. I am attorney Andrew Branca for lawofselfdefense.com. And for those of you who stayed to the end, and I surely hope that's all of you, I'll share with you how you can acquire genuine expertise in the law of self-defense in a single day at our upcoming live-streamed Law of Self-Defense Advanced class. So a few days ago, as Hurricane Helene was about to make landfall in the panhandle of Florida, and with Florida Governor Ron DeSantis having 2 days earlier declared a state of emergency in dozens of Florida counties, the chief of police of the city of Okeechobee made an interesting declaration that effectively suspended the Second Amendment rights of the residents of his city. Specifically, Police Chief Donald C. Hagan II decided it would be a good idea in this state of emergency to prohibit the law-abiding residents of a city from possessing a firearm in any public place, to prohibit all business from even displaying either a gun or ammunition for any purpose, and to prohibit any law-abiding resident or business from selling, offering to sell, or even loaning any gun or ammunition to any law-abiding person in the city. Chief Hagan claimed to have the authority to issue such a suspension of the Second Amendment under Florida Statute 870.044. If such a declaration sounds inane as a practical matter, simply out of concern for public safety during a natural disaster, I'd have to agree it certainly sounds that way to me. Like all gun prohibitions, this declaration could only serve to disarm the law-abiding, who abide by the law. Criminals would continue to possess, display, acquire guns unlawfully as they've always done. Even dumber, however, is the fact that the legislative authority claimed by Chief Hagan to make such a suspension of the Second Amendment is simply illusory smoke and mirrors. In fact, Chief Hagan had zero legislative authority for his declaration, which makes one wonder why his declaration doesn't patently qualify as a deprivation of rights under color of law, a violation of federal law. In fairness to Chief Hagan, rather than continue to paraphrase his Second Amendment suspending declaration, let's go ahead and read the actual thing, what he actually prohibits. It's only a single page, and here it is. So what's prohibited here? It's in those lettered paragraphs. A, the sale or offer to sell with or without consideration, that means for money, any ammunition or gun or other firearm of any size or description. B, the intentional display by or in any store or shop of any ammunition or gun or other firearm of any size or description. C, the intentional possession in a public place of a firearm by any person except a duly authorized law enforcement official or person in military service acting in the official performance of their duty. Note the legal authority claimed by Chief Hagan. He specifies 870.044, and in fact, paragraphs A, B, and C of this declaration are quotes verbatim from that statute, which we can see here. Here, I'd like to focus primarily on that third substantive paragraph, having to do with possession of a firearm in a public place by any law-abiding person, not a law enforcement officer or engaged in military service. That's not to diminish the egregiousness of the first two paragraphs dealing with the sale or display of guns or ammo, but I've got to be real with all of you here. If you're waiting until you're actually in a state of emergency before you try to acquire a gun and ammo, you're just doing it wrong. In a severe emergency, the places that could display or sell you guns or ammo probably won't be in a position to do anything of the sort in the near term anyway. If you recognize that having guns and ammo may be of practical utility during an emergency, during which 911 may be even less responsive than normal, and during which violent looters may be taking advantage of the opportunities the emergency is making available to them, the time to acquire such guns and ammo and the training to efficiently and lawfully use them is today, not during the emergency. Still, the notion about being prohibited from providing a gun or ammunition with or without consideration in the first paragraph, and without consideration here simply means you're lending a neighbor a gun for lawful purposes and not charging them for the loan, does seem particularly morally offensive. In any case, again, let's focus on this third paragraph. The intentional possession in a public place of a firearm by any person not a cop or in military service. That any person being prohibited is you. So if during the state of emergency you need to exit your private property and go out into public to secure water or food or medicine or trauma care or whatever, this declaration mandates that you do that while leaving your lawfully owned guns at home so that you're effectively defenseless amongst the non-law-abiding criminals who will, of course, continue to go about armed in violation of this declaration, just as they violate all laws they wish. Perhaps the most egregious part of this declaration, however, is what it doesn't say. Because while it largely quotes verbatim from Statute 870-044, purportedly its authority, the declaration mysteriously fails to include the last sentence of that statute. And that final sentence reads, as you can see, "Nothing contained in this chapter shall be construed to authorize the seizure, taking, or confiscation of firearms that are lawfully possessed unless a person is engaged in a criminal act." Legislatures being legislatures and not necessarily the best and brightest that society has to offer, the language here allows for a certain degree of ambiguity. If 870-044 doesn't allow for the seizure, taking, or confiscation of firearms that are lawfully possessed, does that mean that if you're out and about during an emergency armed with a firearm, that the police lack the authority to seize, take, or confiscate your weapon? If they're not going to take your firearm, they're certainly not going to arrest you. Little point to arresting a man you leave armed. So what? They can write you a citation while leaving you armed? Okay, I guess. Or is there a circular argument here that the final sentence prohibits the seizure, taking, or confiscation of firearms unless a person is engaged in a criminal act, and violation of this declaration would qualify as precisely such a criminal act? I don't know. And the reason I don't know is that the Florida legislature and Florida courts don't tell me, or you, or anybody, how we should understand the ambiguity of this language. When lawyers want to research the full scope and limitations of the statute, we typically use our professional legal database tools to search through annotations to the statutory record. Annotations give examples of how courts have applied this statute in the past. We'll also look at the appellate court records to see if there's any case law applying and clarifying the statute. In the case of this statute, 870-044, however, there are a grand total of 0 annotations illustrating prior use and 0 appellate court decisions involving the statute. In fact, it would appear from a legal perspective, 870-044 may never before have been substantively applied. In any case, if a lawyer like me can't clarify a statutory ambiguity, I wouldn't hold out any great hope that a local city police chief or a street cop or a National Guardsman serving during an emergency is going to have a substantively better understanding of this law. It would be nice if the Florida legislature clarified this ambiguity so everyone involved better understood where they intended to draw the legal boundaries, and so any substantive infringement of the Second Amendment could be attacked well before any emergency, but I'm not holding my breath on that wish. All that said, there is some good news here. According to the Firearms Policy Coalition account on X, or Twitter, when Florida Governor Ron DeSantis was informed of the Second Amendment suspending declaration, the DeSantis administration found the declaration to be illegal and unconstitutional and directed Chief Hagan to rescind the declaration immediately, which he did. By the way, the Firearms Policy Coalition does God's legal work in protecting the Second Amendment, and if you're on X, I encourage you to give them a follow. Their account there is @GunPolicy. Now, perhaps that action by the governor's office wiping this declaration away could find its way into the legislative record of 870-044 as an annotation, providing guidance on the proper scope of this statute. Even better, of course, would be if the statute were simply rescinded in its entirety as a monstrosity that does nothing but infringe the Second Amendment rights of law-abiding citizens during the very worst possible time, a state of emergency. But I'm not holding my breath on that wish either. All right, folks, I promised you earlier to explain how, if you'd like to gain genuine expertise in the law of self-defense so you can make more confident, better informed, more legal, and more decisive decisions in defense of yourself, your family, and your property, so that you're both hard to kill and hard to convict, you can now gain that expertise in a single day. In just a few days, we'll be holding one of our twice-a-year Law of Self-Defense advanced classes. This is a full-day class taught live by me, live streamed to you at the convenience of your laptop, tablet, or even smartphone. And it makes you a genuine expert in the law of self-defense in just a single day. And for a short while longer, you can grab your ticket to this Law of Self-Defense advanced class at up to 50% off the normal price at lawofselfdefense.com/advanced. Don't delay. If you miss this class, it will be at least 6 months before we do another. So grab your ticket today at lawofselfdefense.com/advanced. And I'll remind all of you, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.